butereevu kansubira nti eddoboozi likkiriya munfuna bulungi mwenna abatuuse mbalamusizzaako Scovia Suzanne Ibrahim Payasi Nakayima gwe yasookeddeko ddala na mwenna abakiriko Rebecca mbalamusizzaako Lemi Hope mumpulira bulungi nnyo. Tuli live mu kkooti ya NAMBI versus NALUKOOLA. Kkooti ya leero erabika nga tegenda kubeera nnyangu. Kkooti ya leero saagala ogisubwe kubanga okusinziira ku mbeera eriwo erabika nga tegenda kubeera nnyangu n'akamu n'akeddagala. Ibrahim agamba otya eno si last hearing, omusango bakyaguwulira bakyawaayo bajulizi abajulizi bakyabuuzibwa akana n'akataano then hearing like bajja kuba batubuulira dde bagenda ogusala era nja kuba mbabuulira. Alex Michael ogamba otya Shivan mugamba yanguwe Ivakan ogamba otya good morning to Emina Haria Michael Scovey and others. Kiwanuka Robert ogamba otya mukulikeyo mwenna bitwadde nabo olunaku lw'ejjo wali mu Busoga obusembatya. His Excellency Kyagulanyi Ssentamu yabadde ng'agenze okwetaba mu kusaba oba ku Thanksgiving ya Mase Walukamba. Oyo nno nga yabadde akulembera EC oba Electoral Commission ya NUP. N'okuweereza Washington ogamba otya mushayalinge mutaginge bonna Shivan Achan ayingiddewo. Oyo nno yanyezeemu kaawo naye katono nnyo tujja kukatereeza. Henry Ssemwanga ogamba otya agamba ali kata ab'ekata mwenna mugamba mutya. Kkooti etudde tulinze mulamuzi kuyingira. Hans Mad agamba nti naye atuuse. Banange waliwo channel ya muganda waffe owokubiri eyatwaliddwa. So mbagamba nti musubscribe ku backup channel yaffe. Kyembeera ntegeeza nti eno yaffe webagitwalira tuba tulina wetwesangira. So kati bwatannaba kusubscribinga tujja kwebulako maana ate nga saagala twebuleko. Tujja kwebulako ate nga saagala twebuleko. Kotyali kkooti ya leero endabikidde okubeeramu omuliro. Oli live ku Shalom Television Uganda. Dr. Enzyme muze nkuweereza. Nakayima ogamba otya Hope mujjukira twakoma nakugamba oyagala eno kesi ekunyumire olina okuba nga ogigoberera. Tumwebaze agamba otya. Nakugamba oba oyagala keesi eno ekunyumire olina okubeera nga ogigoberera. Ebintu tolina biggwamu bugwi. Olina okubeera nga ogoberera settings zonna kyobeera bangezaako okubeera nga nzikuwa. Kkooti ya leero kugambye ndabikidde okubeera nga tegenda NALUKOOLA and the Electoral Commission.
Good morning, my Lord. For the petitioner as well, we are ready to proceed. My Lord, before we do so, permit me to give some contours of how we are going to do this. My Lord, all three of us, the petitioner will submit at various points of the day. My colleague here, Mr. Kiwige Ismail, will start and also set the pace and tone of our submissions. Then the rest of us shall come afterwards. My Lord, we have also prepared authorities. They are contained in 4 volumes, these files. My Lord, they are paginated. I was saying, my Lord, that they are paginated. They run from pages 1 to page 1746. And my Lord, in the course of the submissions, each one of us shall be referring you to a specific page of the bundle where the particular holding that we shall be referring to appears, my Lord. And with that, my Lord, I think we can now start, and we'll start, as I've said, with Mr. Kiwige Ismail. I'm obliged, my Lord.
For the record, my Lord, my name is Kiwige Ismail, and I'm going to take you, my Lord, through the first part. My Lord, I'll take you through the brief facts first. The facts of this petition are not disputed. My Lord, the petitioner and the first respondent participated in the recently concluded general election, by-election, Kawempe North constituency, as candidates. My Lord, the second respondent returned the first respondent as the winner and was gazetted on the 24th day of March 2025. My Lord, the petitioner was aggrieved by this declaration and hence brought this petition, chiefly on two grounds. Ground number one, that the election was conducted in non-compliance with the provisions of the law, and that non-compliance, my Lord, affected the results in a substantial manner. Secondly, that the first respondent and his agents, with his knowledge and approval, committed illegal practices on the election day and before the election day. My Lord, during trial, 4 issues were agreed upon to be disposed of by this honorable court. The first issue, my Lord, was toned a little bit down on the last day of cross-examination when the first respondent applied to expunge a few affidavits. So, my lord, then the issue reads whether the affidavit of Ben Mukasa and Tale, they were free, but 2 of them were expunged. Whether the affidavit of Ben Mukasa and Tale in support of the first respondent's answer to the petition is legally admissible. Issue number 2 for the court's determination is whether there was non-compliance by the second respondent with the provisions of the Parliamentary Elections Act relating to elections, and if so, whether the non-compliance affected the results in a substantial manner. Issue number 3, whether there was an illegal practice or any other offences under the Parliamentary Elections Act committed by the first respondent in connection with the election, personally or with knowledge and consent or approval. Then lastly, my lord, what are the remedies available to the parties? My lord, during the course of the hearing, we indicated to you, my lord, that we shall raise preliminary points of law. The court guided your lordship that we shall raise them at this stage of final submission.
I have an issue with the way he read out issue number 2. I don't think we agree that the way he amended it is not how the court captured it. The issue was whether was that compliant with the provision of the Parliamentary Elections Act, not with the second respondent. And if so, when it affected the results in a substantial manner. So I think it was not specified that we had framed the issue of non-compliance with regard to the second respondent. It was a provision of the Parliamentary Elections Act. So if he addresses it the way, or if it captured it that way, it would affect the way we had prepared the submission.
Okay. That one particularly clear. What I have on record is whether there was non-compliance the provision of the Parliamentary Elections Act, and if so, whether the non-compliance affected the results of the election, the substantial manner. So that's the issue.
I am obliged, my lord. My lord, we indicated, I was saying that we indicated that we shall raise preliminary points of law, and the court guided that we shall raise them at this point of the final submissions. My lord, the first preliminary point of law is that affidavits is in respect of affidavits that predate the answer to the petition. It is in respect of affidavits that predate the answer to the petition. My lord, the record of the court reflects that the answer to the petition was prepared, sworn on the 23rd day of April 2025. It also reflects that the affidavits of David Lewis Rubongoya, the record also reflects that the affidavit of David Lewis Rubongoya, Ben Mukasa, Sylvia Nachobe, Damba Kezekia, and Chibirige Musa was sworn on the 22nd day of April 2025. Now, my lord, the problem with these affidavits is that they support an answer that had not been existent. They are sworn a day before the answer is in existence. And my lord, Rule 81 of the Parliamentary Elections rules permitted the first respondent to file his answer once he was served with the petition. Rule 81, 8. Rule 8, sub-rule 1, permitted the first respondent to file 8, sub-rule 1. Yes, 8.1. Yes, 8.1, my lord. Permitted the first respondent to file his answer, and that answer would constitute a pleading. And his answer would constitute a pleading. My lord, in Kayanja vs. Dipal, this authority is on page 22, volume 1 of our authorities. Is on page 22. It was held, my lord, that the answer. Yes, it is the highlight. That's what page. It starts at page 1, my lord. Yes. It says, my lord, that the answer to the petition is like a pleading akin of a written statement of defense. The answer to the petition is a pleading akin of a written statement of defense. My lord, in an ordinary suit, what this case is trying to tell us, in an ordinary suit, an answer to the petition is the suit, is the written statement of defense. You cannot bring evidence before you file the defense. Before you prepare the defense, you cannot prepare evidence. In fact, my lord, without that pleading, any preceding evidence would be anticipatory, would be speculatory, and court cannot act upon it. I'm fortified by the decision of Phyllis, Wamaisa, Wahimia, and others. My lord, this decision is on page 29. Page 29 is where the decision starts from. They do, my lord. It's my lord, the law contemplates commencement of a suit before an affidavit can be sworn. My lord, you cannot swear an affidavit. You cannot swear an affidavit before a suit is filed. The first respondent could not swear. These affidavits could not be sworn before the first respondent filed his answer to the petition. And my lord, the authority uses the word swore. It's not anything else. It follows, therefore, your lordship, that swearing and preparing of any evidence follows existence of a pleading, which is in this case an answer to the petition.
Okay, Mr. Chidrige, you continue speaking. Just continue. I will just note the few things.
I am obliged. In Welltown Mylord Holdings, Welltown Holdings Property Limited versus Rudo Traders. Yes, this is another decision. It's at page 32. Yes, page 32.
Same volume?
Yes, same volume, my lord.
32.
Yes, it's at 32, but the highlighted part is at 76. Yes, my lord. My lord, this is where the decision starts from. Yes, my lord, that is the case. Welltown Holdings Property Limited. Welltown Holdings Property Limited. The holding, my lord, is on page 76. The Supreme Court of Australia. The Supreme Court of Australia held, my lord, that in the present context, there is no reason in principle to distinguish between an affidavit that predates the demand by 2 days and an affidavit that predates the demand by 13 hours, where the 13 hours difference results in a document being signed on a different calendar day. My lord, what happened in this case is that someone made an application for a demand, but filed an affidavit verifying the application for the demand first. Now, the Supreme Court said that cannot happen. You cannot, that affidavit cannot verify a demand that it predates. My lord, it is like giving birth to the child before getting pregnant. You cannot, our point, my lord, on this issue is you cannot swear, you cannot prepare, you cannot file evidence before the pleading is prepared like it was done in this case. Moreover, my lord, these affidavits tell a blatant lie about themselves. They were sworn on the 22nd before a commissioner for oaths, and they are saying they are supporting an answer that was not in existence by that time. And my lord, the law does not treat that blatant lie lightly. In Mianjamba Bali, my lord, versus Birekera Onsuruga, election petition number 36 of 2011. My lord, the holding is at page 150. Mianjamba Bali, The holding is at 150.
The case itself. Ask the case itself before you go to the
Yeah, the case is on page number 96.
Page 96.
Yes, page 96.
Is that what it-
Yes, my lord.
Okay. Proceed.
It was held in that case, my lord, a sworn affidavit is not a document to be taken lightly. An affidavit which contains falsehoods is suspect on that account. And my lord, the court went ahead to strike it out. We invite you to strike these affidavits out. The holding is at page 150. We invite you, my lord, to strike out those affidavits. First for predating the answer they seek to support, and second, my lord, for telling a blatant lie in view of Mianjambabari versus Suruga Elekera. My lord, the second primary objection relates to the affidavit, to the annexure on the affidavit of the first respondent. My lord, during his cross-examination, the first respondent identified this annexure called the parking list, identified it as a parking list, but my lord, throughout his evidence, he does not make mention of this annexure. When you go to the annexure itself, it speaks about itself as Annexure A. It speaks about itself as Annexure A, but in the whole of his evidence, there is no Annexure A. My lord, this makes the Annexure alien, standalone, makes it alien and standalone to the affidavit of the first respondent. My lord, even if someone was to say that, the annexure is identified as TD, because he has a mention of, he attaches it as TD in his evidence, but when he brings it, it is marked A. Even if we are to, this court was to take that annexure is TD, my lord, it offends rules 8 and 9 of the Commissioner for Oaths rules. For the fact that it was not sealed and commissioned by the Commissioner for Oaths. My point, my lord, is that Annexure 3 attached to the affidavit of the respondent is not sealed, is not commissioned, and it offends rules 8 and 9 of the Commissioner for Oaths rules. But sealing and commissioning of documents is not a matter of choice. Sealing and commissioning of documents is not a matter of choice. It is a command of the law under those provisions that I have just cited. My lord, in Egypt Air Corporation, this authority is on page 158. 158. The holding is on 160. In Egypt Air Corporation versus Starfish International Food Processing Limited, and Pan World Insurance Company Limited. The Supreme Court, my lord, had this to say. We would like to point out that sealing and marking annexures to an affidavit is a legal requirement. Supreme Court. It is a legal requirement which inter alia facilitates the easy identification of annexures, and in our view, the procedure must be adhered to. The procedure must be adhered to. First, my lord, the annexure in evidence is not identified. But even if we say that it is identified as 3, it is not sealed and commissioned. And the Supreme Court is telling you, you must adhere to those provisions which command commissioning and sealing of annexures. My lord, that position was restated. That position was restated. If you go on page 165.
The same point.
Yes.
Same point.
Yes, my lord.
I think one case will suffice for each point. Don't have it in fact so many.
I'm obliged.
You don't have to agree, talk about the same issue.
I am obliged, my lord.
That's one case. Especially if it's the Supreme Court.
My lord, if non-identification of the parking list by the first respondent has not satisfied you, and non-commissioning has not satisfied you, my lord, this annexure has a second defect. It is a document belonging to the second respondent. It is a document belonging to the second respondent given to the first respondent. And my lord, that makes it a public document under section 73 of the Evidence Act. The report, my lord, reflects that that document is not certified. That document is not certified, and therefore cannot be admitted in evidence in accordance with sections 75 and 76 of the Evidence Act. My lord, in cross-examination, when the first respondent was asked why the document is not certified, he said it is a technicality that his lawyers would answer to. My lord, there is no technicality in certifying public documents. The petitioner had 29 documents to certify, and she certified all of them. The respondent had just one, the parking list, and he refused to certify it. My lord, that put it far away from admission in accordance with sections 75 and 76 of the Evidence Act. My lord, in Betty Centum versus Naeva Resilidia, in Betty Centum versus Naeva Resilidia, my lord, this authority is on page 169. Same volume, my lord, volume 1. My Lord, the holding is on page 189. It was held, my Lord, that in the circumstances, a public document ought to be proved as required by the law. The said document cannot be validated because it is an attachment to an affidavit. It cannot be validated simply because it is an attachment on an affidavit, or it was obtained from from a respondent who has not certified it. My Lord, I will stop there. The decision is very wrong. There is no evidence on the part of the respondents that at least they tried to write to the second respondent to have the document certified. There is no evidence of proof of payment. There is no evidence that they tried to make an effort.
It is not certified.
It is not certified, my Lord. My Lord, if the first leg of this objection did not satisfy you, this one should. And we pray that that document is struck off the record of the court. The third objection, my Lord, is in respect of the oath of NALUKOOLA. The issue with this one, my Lord, it became apparent during cross-examination that this witness did not take the oath. It became apparent during cross-examination that this witness did not take the oath. She failed to explain this honorable court how the oath was taken. She failed to explain how the oath was taken, and my Lord, we pray that that affidavit is struck out for missing that element of taking the oath. My Lord, Section 5 of the Oaths Act guides on how an oath is supposed to be taken. In Kapoza John Baptist versus Electoral Commission and Iga Anthony, election petition, appeal number 11 of 2007. Now, this is Supreme Court. Volume 1. Page 195. Page 195. The authority says, my Lord, that the land justices of appeal analyzed minutely the evidence as to when, where, and how the deponent swore affidavit in question. The holding is on page 210. Including the remarks the deponent made during cross-examination. The land justices of appeal concluded that in the circumstances, I find this case differs from both Kiza Vesuje and Bio Jacob. To condone such an unsworn statement seeking to pass as affidavit evidence would undermine the importance of affidavit evidence, which is rooted on the fact that it is made under oath. My Lord, affidavit evidence is rooted from the fact that it is made under oath. My Lord, once the oath is dead, there is no evidence on affidavit. Someone might aid my Lord that the witness took a second oath when they came for cross-examination. My Lord, when the first oath is dead, the second, it is not Jesus Christ that it dies and resurrects, Once it is dead, it is dead. It died then, it could not be resurrected. I invite you, my Lord, to hold that the oath was dead then, and now Costa Rica has no evidence on record. My Lord, at this point, I would give my release key to my learned colleague to take you through the merits of the case.
Your Lordship, Ahmed Mukasa Kalule, I'll handle the first ground and half of the second ground. My Lord, let me, before I start, put a rider on the submissions that have been put by my learned friend, Ismail Tunisia. My Lord, because we don't know at this stage the decision of the court on all of those 3 points, which we'll learn later maybe in the judgment, my Lord, without prejudice, those submissions, we shall in the course of our submissions refer all of those activities. My Lord, let me start my submissions, my Lord, with the burden and standard of proof. Your Lordship, the burden of proof of grounds in an election petition rests solely on the petition. And the standard, Your Lordship, is on a balance of probabilities. That is the provision of Section 80, subsection 3 of the Parliamentary Elections Act. My Lord, we have provided 2 decisions on how the courts have treated the burden and standard of proof. The first authority, Your Lordship, is at page 236. The authority of Tolit Simon Akecha versus Olanya Jacob and EC. But the actual holding, my Lord, is at page 241. Same volume we have been using, volume 1. There, my Lord, of course, their Lordships restated that the burden of proof, the page number where the holding is, my Lord, is at 241 of volume 1 of our band of authorities. I was saying, my Lord, that the Lordships restated that the burden rests on the petitioner and it's on a balance of probabilities. But the catching thing in that decision, my Lord, is that courts, before and after, one would wonder why, before and after, sent mixed signals about the standard of proof of the grounds for annulling an election petition. My Lord, as far back as 2011, in that decision, the Court of Appeal said, please do not be confused about the standard. The standard of proof for all grounds in an election petition is on a balance of probabilities. My Lord, that same position is repeated in Paul Muiru versus Nebeta Nathan. My Lord, that decision is on page 253, but the actual holding is on 281. That is also a 2011 decision. The actual holding is on page 280 and it stops at 281. Now, my Lord, let me make this point also very clear. Even after Kakoza John Baptist, Supreme Court, 2009, even after these two decisions I have referred to, some decisions at the High Court and some at the Court of Appeal continue to confuse the standard. That on offenses, it is slightly higher than the balance of probabilities. These three decisions I have referred to, my Lord, tell you that when you are proving grounds for annulling an election petition, the standard is the same, balance of probabilities. Now, my Lord, that position I'm talking about has now been settled by the Court of Appeal. Last round of elections, in the case of Webday versus EC and Webday versus EC and another. That authority, my Lord, is at page 288. The actual holding is on page 299. So, my Lord, there should be no confusion, therefore, as we progress in the case about what the burden is. I have admitted it rests on the petitioner, and the standard of proof for all the grounds is on the balance of probabilities. Yes, my Lord, that's what Webday says. My Lord, the authority, the actual holding is at page 299. Yes. (299) is the actual holding. It says previously there was indeed some controversy on the standard of proof in election petition. This court in Admissibility of FARIDAH, Nanzili Kasemu Banda, Mary Abile Kabanda, recently put the matter to rest by finding that the standard of proof set out in section 61.3 now is 83 of the PEA, which provides that any ground, the word any, my Lord, is catching, any ground specified under 61.1 shall be proved on a balance of probabilities. My Lord, my Lord, it says any ground, and election offences are part of section 61.1. Well, my Lord, our interpretation of this of that the thing that we have given you, and even, by the way, my Lord, in Kakoza John Baptist, I will get to it later, but it's this, that's in that case, my Lord, the Supreme Court found bribery in Kakoza John Baptist, and it was proved on a balance of probabilities. I will refer to it on other issues. I think that we have already referred to it. We have actually already referred to it, my Lord. If you could go back on it. That's 210. Yes, but let me double check, my Lord.
So, where does it say the citizen?
My Lord, what I'm saying in Kakoza, John Baptist, is that my Lord, I haven't just remembered that specific issue. I haven't, I didn't raise my mind on that point in that decision, but The point I was making, my lord, is that in this decision of Kaposa John Baptist, and in the decision, by the way, my lord, of Mukasa Anthony Harris, which we have not provided because we didn't anticipate that issue. Mukasa Anthony Harris, both of the Supreme Court. Actually, my lord, the standard that I've been referring to in all of the three decisions I've just referred to, we are saying that in Mukasa Anthony Harris, the Supreme Court has guided that the standard for all grounds is on a balance of probabilities. My lord, we shall provide that authority of Mukasa Anthony Harris. That's where all of this decision I'm referring to. We are saying the Supreme Court clarify that for all of them, it is on a balance of probabilities. Mukasa Anthony Harris versus Dr. Lulumeba Ike. Supreme Court shall provide that decision, my lord. And it is that all of these authorities of the court were being, even when paid, that I've just cited, my lord, this past. Now, my lord, I will be content that I have discharged the burden and standard if I am able to convince your lordship as a reasonable tribunal that a fact is more probable than not. That's what balance of probability means. That taking into account the evidence of the petitioner and that of the respondent, a fact is more probable than not. That is what the standard of balance of probabilities means. My lord, that is the decision of Miller versus Minister of Pensions. If I attain that standard, my lord, and you're convinced, page 383, that's where the holding is. .383 is where the actual holding is, page 383. But the case, your lordship, starts at 382. There, my lord, their lordships said that the degree is well settled. It must carry a reasonable degree of probabilities, but not so high as is required in a criminal case. If the evidence is such that the tribunal can say that we think it's more probable than not, then the burden is discharged. Then the burden, my lord, is discharged.
What's the name of the
Miller versus Minister of Pensions. 382, the holding is at 383. My lord, which now takes me to the first issue. The admissibility of the Affidavit of Ben Mukasa. My lord, we have submitted a lot about this issue, so I will not say too many things about it. Suffice it to say, my lord, that Chamber Nathan Mwanguzi and George William Maumbe on the 9th of April deposed affidavits in support of the petition. My lord, those affidavits were filed together with the petition. No, those in support of the petition. Mine, my lord, yes.
one that was covered
Of the first respondent, yes, my lord. And I'm saying, my lord, that as it became apparent during the examination, they explained to the court the egregious circumstances in which they had sworn the second set of affidavits, which were removed from the record of court. My lord, we have already argued that that which Ben Mukasa did, and is clear from his affidavit, clear from those affidavits which were expanded, clear in the examination report here, is against the tenets of a fair trial. My lord, we are dealing
that you were not happy with, which are the second set. Those were your struggle.
My lord, now we are dealing with that of that.
If I understand you are saying that Mukasa is the one that
Yes, that's what I'm saying.
there are no more.
Yes, no, my lord, what the point I'm
What is your grievance in Mukasa?
the Ben Mukasa, my grievance is this, my lord, that he perpetrated the illegality that the court has identified, that counsel for the first respondent has identified, and has led to the expungement of those affidavits. So my question, my lord, is if this Ben Mukasa has then granted the tenets of a fair trial by doing what he did, by procuring this illegality, by ensuring a fair trial does not take place in this matter. The question then should be, should we allow him to continue participating in this trial? A trial that he does not believe in, or at least its fairness. And as we have already shown you, my Lord, previously when we were arguing that approaching witnesses of the other side is unlawful. And Ben Mukasa has said that. These witnesses came to court and said that. That is illegal, and we have identified that again. Now the issue is, should we allow Ben Mukasa to continue being part of this trial? My submission, my Lord, is that he should not be allowed to continue participating in this trial. We have identified an illegality. Leaving his affidavit on the record of court would be to sanction his conduct, to sanction his illegality. That's the effect. If we agree that what he did is unlawful and illegal, then leaving his affidavit on record is sanctioning that illegality, which the Court of Appeal has been very clear about. Don't touch the other side. This man came to court and said in his affidavit that he's the one who did it. As it became apparent in the examination, he did it. It is illegal, and we have identified it. Now, can we keep the illegality on court, my Lord? Is our submission that we should not. My Lord, of course, for that position, I refer to the oft-cited case of NALUKOOLA International versus Emmanuel Cardinal Amara. My Lord. That authority is at page 449, but the actual holding is at 467. 467 is where the actual holding is. Yes. 467, yes. Same volume I've been using. The case starts at page 449, my Lord. So, my Lord, my prayer, therefore, on that affidavit is that be struck out. Be struck out. Second issue, my Lord. Whether there was non-compliance with the provisions of the PEA relating to elections, and if so, whether the non-compliance affected the result of the election in substantial manner. My Lord, as I spoke earlier, Section 80, subsection 1 provides for the grounds for setting aside an election petition. This ground we are dealing with in this issue is Section 80, subsection 1A. Section 80, subsection 1A. An election of a member of parliament under that section is set aside where there is proof on the balance of probabilities that there was non-compliance with the provisions of the PEA relating to elections, and that non-compliance affected the result of the election. My Lord, let me preface my arguments on this issue by making two legal points. The first one, my Lord, it is irrelevant to succeed, for the petitioner to succeed on this ground. It is irrelevant that the non-compliance or elements thereof are attributed to the winning candidate. It is not necessary, my Lord, for the petitioner to succeed on this ground that any elements of non-compliance are attributed to the winning candidate. What the law requires, my Lord, is proof of non-compliance, and whether that non-compliance affected the result of the election in a substantial manner. That is why you saw, my Lord, throughout all our evidence, body of evidence, we did not attribute the elements of non-compliance to the winning candidate. It is irrelevant, it is not necessary. My Lord, that's the decision of the Court of Appeal in Mbaju Jackson versus Tembo Gideon Mujongo. My Lord, we have now shifted to volume 2. Mbaju Jackson versus Tembo Gideon Mujongo and another. That decision, there is the first one on volume 2. Okay. That is page 169. It's the first case in volume 2 at page 469. But the actual holding is at page 501. The actual holding, my Lord, is at page 501. If I could just... The holding is at 501, page 501. It's just paragraph 93, my Lord, where their Lordship said that the law does not require that irregularities or unlawful actions be attributed to the successful candidate whose election is challenged. Section 61(1)(a), now 81(a) of the PEA requires the court to be satisfied with two things. First, that there was failure to conduct the election in accordance with the principles laid down in those provisions of the law, and second, that the non-compliance affected the result of the election in a substantial manner. That's the first legal point. Secondly, Your Lordship, the second point I wanted to preface this argument with is that it is also irrelevant and it is not a plea available to the winning candidate, in this case the first respondent, to say that the petitioner may also have committed acts of non-compliance. That plea is not available. It is not a defense, okay, to a charge, to a ground, to this ground, my Lord, for the first respondent to allege any sort of malpractices against the petitioner, as the first respondent tried to do so in paragraph 3 of his answer to the petition. My Lord, that point of law was also settled by the Court of Appeal in Ngomanjime versus the answer, first of all, yes. Paragraph 3, he attempted to allege that the petitioner committed some acts of malpractice. That is not open to him. It is not even a defense. So consideration of whatever the petitioner may have done is irrelevant to this ground, at least, my Lord. And I'm saying, my Lord, that that point was also settled in the Court of Appeal in Ngomanjime versus EC and Winbianyima. Ngomanjime versus EC and Winbianyima. The authority starts at page 512 in our second bundle, in our second volume. But the actual holding, my Lord, is at page 524. The authority starts at page 512, my Lord. But the actual holding is at page 524. We have highlighted the relevant part, which is the effect of what I'm saying. In summary, my Lord, their Lordships are saying the law is concerned with the winning candidate. There is no logic in pursuing the losing candidate. The law is not concerned with that. So it is irrelevant when we are arguing this ground that the petitioner may have, as I saw the counsel for the first respondent try to bring out at some part of the examination. Now, my Lord, in paragraph 7.3, that's at page 4 of our petition. The petitioner pleaded a number or several elements of non-compliance with the law. This is in the petition at page 4 of that petition. Several elements of non-compliance were pleaded there. I may not repeat them, my lord, because they are already in the petition. Summary may be, or it may suffice for me to say, that the complaint was about the holding of the election in an environment that's not free and fair, non-counting of votes cast at these polling stations, the 14, my lord, the non-transmission of results, the non-filling of the DR forms, the non-tallying of these results, non-delivery of the tamper-proof envelopes, and final declaration of a winning candidate without receiving all envelopes from the constituency as is the command of the law. That was the substance, my lord, of the elements of non-compliance with the provisions of the law. My lord, in the petition, we specified the provisions of the law which were breached. What did the respondents do in their answer? First, my lord, of course, my lord, I could also probably mention that the petitioner gave evidence in support of those claims together with her agents. Now, in answer to the petition, let me begin with the first respondent. What does he say? In paragraph 4 of the answer to the petition, he says, yes, there was 0 return from those polling stations. My lord, that concession in paragraph 4 of the answer to the petition is repeated in paragraph 6 of the affidavit in support of the answer to the petition. When he was here for cross-examination, my lord, he told us that he had polling agents at all the 197 polling stations, and that none of them had come back to tell him that elections did not take place in these 14 polling stations. Pressed further in cross-examination, my lord, he admitted, 1, that there was non-counting of votes. He admitted, 2, that the other forms were not filled. He admitted from the look of the tally sheet that the results were not there. All of those elements of non-compliance were admitted while the first respondent was on the stand. Now, for the second respondent, paragraphs 10 and 11 of the answer to the petition, paragraphs 10 and 11 of the answer to the petition, and paragraphs 9 and 10 of the second respondent's answer to the petition admit a greater majority of those elements of non-compliance. Admit a greater majority of those elements of non-compliance. My lord, we will retreat and read those paragraphs. You will see what I'm saying. Further, my lord, the second respondent filed 5 other affidavits. When you gave them leave to do so, they filed 5 other affidavits of Ahawe Fiona, Peace Shogabiwe Mugabe, Kamsime Tuhemba, Tamale Simon Peter, and Kakaire Gabastas. All those affidavits were filed on the 5th of May by your leave. Now, my lord, the silver lining that cuts across all of these 5 affidavits, which are the evidence of the second respondent, is that 1, there was non-counting of the votes at these polling stations. 2, that as a result of violence, this counting was not completed, and therefore that no DR forms were filled at these polling stations. This was the evidence of the second respondent. And from that body of evidence, my lord, starting from the petitioner, the concessions of the first respondent, the concessions of the second respondent, it is our submission that all elements of non-compliance that were pleaded by the petitioner were proved or have been proved. Why do I say, my lord, that all these things we pleaded were non-compliance? I refer you briefly, my lord, some of the decisions that have held that each one of those things that we pleaded is non-compliance. Maybe perhaps, my lord, to tell you that non-compliance simply means that there's provision of the law which has not been complied with, as simple as that. If the law tells you count votes, you don't count them, that's non-compliance. Fill DR forms, you don't fill them, non-compliance. Take all envelopes before you declare, you don't do so, non-compliance. That's simply what it means. And in the petition, we specified all of those sections that the second respondent did not comply with. They told him to do something else, he did something else. Now, my Lord, I could refer you some of the decisions in our bundle of authorities that have held that all of these various things that we pleaded and which we have stated have been proved are elements and amount non-compliance with the law. The first one, my Lord, is at page 543. 543 of our bundle of authorities. This is the case of Apollo Cantinti versus Stella Samaru. The actual holding, your Lordship, is at page 566. Very small line down there. Your Lordship is telling you that if you don't study, that's non-compliance. Yes, 566. That's where the small holding is at the end of the page. We have highlighted it. The second authority, my Lord, is Joika Furakabatsi versus Anifa Kawoya, Supreme Court. That one is on failure to prepare or fill DRA forms. The actual holding is at page 631 to 632. 631 to 632. 631 to 632 is where the actual holding is. There, in very few words, my Lord, their Lordships, the Supreme Court said DRA forms are mandatory. They are not a matter of form, they are a constitutional command by virtue of Article 86, 68 rather, 68, 2 and 4 of the Constitution. So they held their Lordship, the Supreme Court, in that matter, that DRA forms are not a matter of form. In fact, my Lord, the Lordship went as far as saying if you do not have a DRA form at a polling station, you cannot declare the result of the election, because that DRA form is the basis of the declaration. Next, my Lord, is the case of Acheng Sarah Opendi, same volume. Acheng Sarah Opendi and another versus Ocho Nyakecho. That decision, the holding is at page 678. Actual holding, my Lord, is at 678. There, my Lord, in that decision, as you go there, 15 DRA forms had been tampered with and did not end up at the tally center. The Lordship, their Lordship, so in the Court of Appeal said that the failure to transmit those DRA forms, as was in this matter, no DRA forms were transmitted, amounted to non-compliance. EC versus Moscow, just briefly take you through, my Lord, decisions which have held that all of these things we have pleaded constitute non-compliance. That's what I'm taking you through briefly, my Lord. It's at page 701, same volume, and 701. The actual holding, my Lord, the page I'm referring to as where the actual holding is, but of course the case starts at 686. 686. But the actual holding begins at page 701. Their Lordships were interpreting a section, my Lord, of the Law Governments Act that is pari materia with that of the PEA relating to postponement of counting and tallying of results. They said the EC had that option to postpone counting of votes, as in this matter, postpone voting, as in this matter. They had those options under the PEA, they did not take them, and instead went ahead and declared a winner without those 14 polling stations. That is non-compliance, my Lord. It was held in EC. My Lord, first of all, my Lord, if according to the evidence of their own witnesses, they are saying there was violence at these polling stations, and the materials were destroyed, by the way, they say that as well. Now, they could have postponed the election to the next day. My Lord, that's section 12 of the Electoral Commission Act. 12 of the Electoral Commission Act. My Lord, I say 12(1)(e). That is the section, my Lord, that they use. It says the Commission shall subject to and for purposes of carrying out its functions under Chapter 5 of the Constitution and this Act have the following powers. E, to take measures for ensuring that the entire electoral process is conducted under conditions of freedom and fairness. My Lord, the lordships in the Court of Appeal have said that is that's the section that permits them to cancel.
That's the section.
That permits them to cancel. My Lord, I have not carried, but I will bring it, my Lord. Then, my Lord, back to the PEA, Parliamentary Elections Act. Section 64 allowed them to postpone polling of the PEA. 64(1), where polling at a polling station is interrupted by a riot or violence or any other event the presiding officer shall adjourn the polling to the next day. Yes, for polling, my Lord. Then for...
So in this case, was there interruption of polling? Was there interruption of polling, or it was just counting?
It was counting and tallying, my Lord.
So the polling was uninterrupted?
The polling was interrupted, my Lord, as we said. Then, my Lord, section... Yes, then section 76, my Lord.
76?
Yes. Section 76, my Lord. Maybe it is more direct what you want, my Lord. It says where counting, tallying, or recounting of votes is interrupted by a riot or violence or any other cause, the presiding officer or returning officer shall adjourn the counting, tallying, or recounting to the next day. Section 76, my Lord. So I'm saying, my Lord, they had these options and they did not take them. And that amounted to non-compliance in view of the decision of EC versus Moscow that I've just referred to. Moscow, EC versus Moscow, Jacob. EC versus Moscow, Jacob. The page.
The next case.
Yes, my Lord.
The next, it has to be the next day.
Yes, my Lord. The section I've just read says the next day.
76.
Yes, my Lord. 26(1). Of the offense, 701. That's where the holding is. 701. What the lordships were saying in Moscow is that they had that option to postpone counting, tallying to the next day. They did not take it. That amounted to non-compliance. My Lord, just two more in that area. Amorpol, the decision of Amorpol versus Okero John Baptist. The holding is at page 718, but the case begins at 706. 718 is where the holding is, but the actual holding is at, no, 706 is where it begins. The actual holding is at page 718. My Lord, that one is about transmission of results. In that case, only one DR form had not been transmitted. It had disappeared somewhere along the way and did not end up at the tally center. Their lordship say the non-transmission of that DR form amounted to non-compliance. Lastly, my Lord, on this issue is our plea, my Lord, that the winning candidate was declared on provisional results without first receiving all envelopes from the constituency. I rely, my Lord, on the decision of Betty Mzanira Bamkwatsia, Betty Mzanira Bamkwatsia versus Winfred Comhaj. That decision is at, the holding is at page 751, but it starts at 744. Betty Mzanira Bamkwatsia versus Winfred Comhaj. The actual holding is on page 751. In that same volume, my Lord, that we are dealing with.
So where is the provision of that?
Yes, my Lord.
Where is the provision of that?
Absolutely, my Lord. Because the law requires, my Lord, that before you declare a winning candidate, you receive all envelopes, all DR forms of the consequences. The only exception that their lordships have created in this decision of Bank Muzanira is if the results that have not come are officially cancelled. That was not the case.
This case were able to cancel?
No, they were not. They were not cancelled. The returning officer simply proceeded to declare the winner without receiving all results from the constituency, my Lord, as is the command of section. Let me begin with the law, my Lord. Section 72, the PEA, which their lordships in Mzanira were interpreting. If you are interpreting in the former section 58, now it is 72, 1. Now it is 72, 1. It provides, my Lord, that 72, 1 says after all the envelopes containing the declaration of results forms have been received, the returning officer shall, in the presence of the candidates or their agents, or such of them as wish to be present, open the envelopes and add the number of votes cast for each candidate. You do not declare a winning candidate without all envelopes. Now, my Lord, in Bamzanira, they said, of course, you can begin tallying. Okay, if there is, and that's also provided for in the law. You can begin tallying, but declaration, you do not do so until you have received all envelopes. I was saying that the exception, my Lord, they created is of the decision, my Lord. I'm at page 751 now. 751. I'll get for you the page of the exception, my Lord.
And as you look for what makes the results provisional?
If they're not complete, my Lord, that's all. If a constituency has 197 polling stations and you have results of 170 polling stations, they are provisional.
It's not the case where they say 10,000 votes, and after more carrying, the votes maybe 12,000. So in that case, we say yes, the other 10,000. Now more results are carrying, and total votes cast are 12,000.
Even that, my Lord.
That's why we say
Even that, my Lord.
10,000, but now more votes are counted, now total votes cast is 12,000. But in this case, it never changed.
Even that, my Lord, which you have said, happened and is unlawful. First of all, what you have just said happened in this case and is unlawful. Okay? At the time of declaration, the results were different. At the time of gazette, the results were different. In Muzanira, the Court of Appeal has said that is unlawful for the returning officer to do, first and foremost. This decision has told you once you issue a return form for transmission of results, you can't touch it.
So you were saying they were different.
So-
declaration. What were these covered in your evidence?
My lord, I only put the final declaration where that which you are
You
saying.
don't have that in your evidence.
No, my lord. The previous results have, but that was not my point. The point was that because you do not have all 197 envelopes, BR forms, the only implication is that what you have declared are provisional results. I was, my lord, taking you to the exception that you had asked me. That same page, 751, where I am. Just below the second highlighted part, there, my lord, they are saying, unless they are cancelled. And the second respondent did not tell us that they cancelled. They did not. And cancelling, my lord, is not by implication.
Unless they are cancelled.
We appreciate, my lord, after the second highlighted part,
After the
down there, after the second highlighted part, down there it says, we appreciate that there are cases where certain results may be missing or cancelled. And the available results are used to declare a winner. None of those applies to this case. They were not cancelled, they were not missed. So that's non-compliance, my lord. So the law commands the returning officer to only.
You were saying they were not missing.
They were not
You
missing.
say they can't confirm.
No, my lord, my lord, you cannot miss something that doesn't exist. This was a question of non-existence of that, not missing results. Missing results is this: that results have been declared, like in Nyakechu, Saropen. Results have been declared, the other forms have been filled along the way, the transmission. Then they disappear. The Court of Appeal has dealt with missing results. These were not missing because they were not there in the first place. So I'm saying this therefore does not apply to our case. And cancellation, my lord, is of course, you can't do it by word of mouth. Okay, there is a procedure, my lord, if you want to cancel results. And the EC has not said, my lord, that they cancelled. Not at all.
So if they were not there, what is the expectation?
What? Then the question, my lord, would be, what does the law tell them to do? I've just referred you to the law. Postpone. Yes. The voting. Okay, to the next. And how? Because you see, my lord, after the election is held, the law commands the EC to declare a result in 48 hours. They still had time. Yes, so they could have held the election again in those 14 polling stations. The next day, the law gave them that option, and they did take it. Now, my lord, which brings me to the second limb of this issue, which is the issue of substantiality. Now that, my lord, I have told you and I have given you authority and evidence that there was non-compliance with the provisions of the law, the next issue is whether that non-compliance affected the result of the election in a substantial manner. My lord, I will begin with the decision of Elizabeth versus 7. We all know it's a very huge decision, but it's the excerpt I'm referring to is reproduced in the case of Bantali Isatali versus East. Basically of 201. Bantali, where that excerpt is quoted, is at page 818. But the case starts at 793. Bantalibu Isa Kaligola versus Isi and Oronedem, 2021. The excerpt I'm referring to of Giza BCJ is captured there. Page 818. 818 of the second volume. My lord, is 818. That's where the holding is, but the case starts at 793. The case of Bantalibu Isakaligola versus TC and Orede. Now, my lord, permit me, my lord, to refer to that excerpt. I will not read the whole of it, but towards the end, his lordship was trying to explain what substantial effect means. He says, that means that to succeed, the petitioner does not have to prove that the declared candidate have lost. It is sufficient to prove that the winning majority would have been lost. Such reduction, however, would have to be as to put the victory in doubt. What does that mean, then, my lord? It means that in this petition, we don't have to prove, my lord, that the winner would have lost or that the loser would have won. It is enough in this petition, my lord, if we prove, and we have, that the number of people whose electoral choice was not ascertained by the Electoral Commission is greater than the margin between the two candidates, between the winner and the first runner-up. That is what we have to prove. I will have established substantial effect, my lord, if I prove that because of this number of people whose choice we don't know, because nobody knows how they voted, is greater than the margin. My lord, the margin between the first respondent and the petitioner is 8,881 votes. Those whose choice we do not know, but we are clear voted at the election, is 16,640 votes. They are almost double the margin. They are almost double the margin. 16,640. 640. But the margin.
You have the big tip there. Can you check the total? You can reduce this 16,640. 640. From the 16,640.
Yes, I didn't get your question, my lord.
16,640.
Yes.
The number of total voters in those
14 points. Yes, ma'am.
I want your people there to check the total number by checking
The tally sheet.
no,
So subtracting this from
by
the.
taking by looking at the attach the rows, the voters' rows.
Yes, my lord.
The voters' rows.
Yes, my lord.
You can then check us. Also add up all the voting stations.
Okay, they will do that, my lord, as we go. But you can also get.
Whether that is the figure.
Okay, my lord. But you can also get it, my lord, from the tally sheet. The tally sheet gives you the number of registered voters per polling station and those who voted. If you look at the tally, it would be easier, my lord. But even that they can do from here. But you can easily get it from the tally
Do
sheet.
that.
Okay. Camouflage. Now, what I was saying, my lord, is that the margin between the winner and the first runner-up with the petitioner is half of that number, nearly half of that number, at 8,881 votes. When she was here in cross-examination, she probably also say this, my lord, when she was here for cross-examination, and Mr. Baz took her on it quite a bit, the petitioner stated that in those 14 polling stations, apart from the fact that that's where she votes from, in one of them, but those were also her strongholds. And that evidence was not challenged, my lord. My lord, why I mentioned that point is because the case overturned Okia Moses versus EC and Aliko Hubbard of 2021 turned on that point. But I'll refer to it, my lord, at page 954. It turned on that point. Okay, the appellant in that case said, these areas which have been excluded from voting are my strongholds. It was not challenged at the Court of Appeal, my lord. The case turned on that point. At page 954 of our bundle of authorities. Well, that's now volume 3, my lord. Atan Okia Moses versus Aliko Hubbard. 954, yes, it begins at 9:33, but the holding is at 9:54. In fact, my lord, when she was here, Mr. Baba said, hey, those were strongholds, okay, have the votes, have them. That was and she actually gave them the vote. So the fact that they were not, they were strongholds was not. Now, my lord, let me also give this test, because it might be confused. How do we get substantial effect? Because I saw the first respondent trying to bring another formula when the courts have told us what. How do you get substantial effect? My lord, you do not use the number of people registered in the whole constituency. Why, my lord? For example, in this matter, the results of 183 polling stations are ascertained and unknown, and there is no power with you. So if you want to get whether those people who did not vote had substantial effect, you don't use that number vis-a-vis the total number of voters in the constituency. We are not concerned with people whose electoral choice we know. How do you get substantial effect? You get it by comparing the margin between the winner and the runner-up, who is the petitioner in this case, vis-a-vis the number of those people whose electoral choice we do not know. Therefore, my lord, in this matter, we are comparing 16,640 vis-a-vis 8,881. That vis-a-vis 8,881, which is the margin, yes, between the first respondent and the petitioner. My lord, I am not getting that from my head, but from the decisions of the Court of Appeal, 2 of them. I'll take you back a little bit. The decision of EC versus Moscow, 2021. That's volume 2. That's volume 2, my lord, at page 702. What is volume 2? Page 702. That is where what I'm saying is. EC versus Moscow. Page 702.
What does that assume?
That's preferred, my lord. Maybe, my lord, as I look for that exact holding, I didn't appear to have highlighted it. Let me begin with the Acheng Saro Pendi at page 680. Page 680. in how we get the substantiality effect. Page 680, checks are opened and another versus. Open, my lord, starts at just a minute. Starts at 664. But the holding about this issue, my lord, is at page 608. I've highlighted it. My lord, the point is this. If you look at what we highlighted, what I'm saying is, when you are getting substantiality, you do not take into account the number of registered voters in the whole constituency. So the court said this, my lord. The land judge should have considered the total number of voters in those 15 polling stations. Here the issue was about 15. In those 15 polling stations, which was 7,000, that number, as compared to the winning margin of 7,600 without the same polling stations. But on page 680, we have highlighted that small part there. It's page 680. So that's how we get substantiality. My lord, back to Mosupo. Back to Moscow at page 702. 702. Back to Moscow at 702, my lord. It's paragraph, I think, 445. The one that has 445 at the left-hand side. It's not highlighted, but it says the court was trying to find out, my lord, what the number of the registered vote, what the number of those who had not been counted was, in order that they could compare with the margin. Now, my lord, let me underscore what I'm saying. Okay. If they can be looking for it. Now, my lord, let me underscore something as I get away from that point. And it's critical, my lord, that's why I'm going around and about it a number of times. The first respondent's theory is that if you want to know whether the election was affected substantially, you look at the small number of 16,440 vis-a-vis the number of registered voters in the constituency. I am saying that is a wrong test. And I've given you the reason, my lord. You do not, in that test, take into account the number of people whose electoral choice has been ascertained. In this matter, my lord, the electoral choice that was not ascertained was only to do with 14 polling stations, whose total number of registered voters is 16,640. When we are looking for substantiality, it is that number, because it is those that we do not know how they voted, vis-a-vis the margin. If we find that those whose electoral choice we do not know is greater than the margin, then the election is put in doubt. Why? Because we do not know who would have voted what, at which polling station, what voter turnout. The mere fact that is greater, therefore, has the capacity to change the result of the election. Not change it for the winner to lose, not change it for the loser to win, but as to put the election in doubt. That had to be underscored very critically. Now let me take you, your lordship, how the courts have applied this test standard. the Court of Appeal, how it has applied it, what exactly I'm saying. I'll begin with Apollo County. Yes, I'll begin, my lord, with Apollo County. In volume 2, my lord, the holding that I want is at page 573. 573. What was the problem in that case, my lord? The problem was that results from 9 polling stations were not included in the final tally. Results from 9 polling stations were not included in the final tally. My lord, I was telling that is at page 573 of the second volume. We have read the first quantity, but we can just go back now for this point. 573. And we have highlighted the lordship. Their results from 9 polling stations with over 5,000 voters had not been included in the final tally. The margin from the decade results was as low as 326 votes. Their lordships had this to say, my lord. In our view, in view of our finding above that the 9 polling stations had not been included, we do agree with the land trial judge that the outcome of the results of the whole Chadondo East constituency was left in doubt. The non-compliance, therefore, affected the outcome in a substantial manner, and the trial judge was justified in annulling the election on that ground. See, my lord, their lordships are not touching voters whose electoral choice is no. No. Only the 5,000 vis-a-vis the winning margin. And because the number of 5,000 was far greater than the winning margin, the lordships held that the election was affected substantially. I'll go to the next one, where this was applied as well. Wakaima Msoke Nsereko. Wakaima Msoke Nsereko, my lord, the case begins at 831, and the holding is at 870. I think we are in the second volume, page 831, but the holding is at 870. I think it's something that I did that matter. And he lost this very point. Yes, but my lord, the holding is at 870. 870 is where the holding is. I was just reminding Mr. Louis that he lost this point in that case. There are your lordships at page 870. They said, we agree with the trial judge that the total number of 17,239 registered voters in the 24 affected polling stations whose results were cancelled affected the outcome of the result in a substantial manner. Again, only those whose electoral choice was not considered, not total number of voters. Permit me, my lord, again to take you to Petition Mzanira Mukasa. Permit me to take you back to Petition Mzanira Mukasa at page 755. The authority begins at Petition Mzanira Mukasa versus Winfred Komhanji. The authority begins at 744. but the actual holding is at 755. There, my Lord says the decision applies to this case after quoting content, Apollo, which I have just referred to. They said the decision applies to this case. The returning officer neglected to tally a substantial number of votes, totaling 5,413, and he disregarded the same in his declaration of the elected candidate. Certainly went to the root of the electoral exercise. It amounted to disenfranchisement of the voters. Votes were not considered in the declaration of the winner. Then down there it says, consequently, the disenfranchisement of those voters substantially affected the outcome of the election, since the results declared and contained in the return form indicated a much lower margin of 4,000. Then Muhindo Rehema, my Lord. Muhindo Rehema versus Wilfred Kiza, 90. Yeah, in volume 3, I think, my Lord. Page, the first authority on page 3. Volume 3, yes. The holding is at page 890, my Lord. There, my Lord, 13,426 had not been considered. That first paragraph on top, my Lord. And the Lordship said that was significant to affect the result of the election in a substantial manner. Now, let me also say some of these legal points, my Lord. The first one, when we are determining substantiality, my Lord, the number of polling stations that the winning candidate has won vis-a-vis those of the losing candidate is irrelevant. As you saw, my Lord, from the theory of the first respondent, he attempted to tell us that, look, I have won in so many. I would have won in those others. Before I get to that, the number of polling stations that you have won is irrelevant. My Lord, I take you back to Mbaju Jackson at page 501. This is the second volume. Mbaju Jackson versus Tembo Gideon Mujungu, page 501 of volume 2 of our bundle of authorities. The actual holding is at 501. That case is the first one of volume 2. My Lord, paragraph 92. The Lordships in the Court of Appeal say it is true that neither the applicant nor the respondent number 2 won at any of the disputed polling stations. Just like here, we don't know who won. However, this cannot lead to the conclusion that such malpractices did not affect the result in a substantial manner. The election is won by the total number of votes cast and not by the number of polling stations at which the candidate wins. So that issue should be out of the way. It should not disturb your analysis, my Lord. Secondly, my Lord, the other point I wanted to emphasize on this issue as I walk away from it, it is irrelevant. It is theorization for the first respondent to say that because I won in the majority of the polling stations, I would have won even in those polling stations. And therefore, because he's saying that to say, my Lord, that therefore the election was not or could not have been affected substantially. That theorization, my Lord, when he came here in his answer and explanation and began talking about trajectories, patterns, and those kinds of things, my Lord, I'm saying that is without legal basis. For you to say, my Lord, that because I won there, I could have won there, that guesswork, as I called it, my Lord, as a reason for saying that the election could not be affected substantially is without legal basis. Adding the number of votes and subdividing, as Mr. Mbabas took my client through, is without legal basis. It is guesswork. And my Lord, of course, if it is not lawful that courts do not act on guesswork. They act on real evidence. For that, my Lord, I've given you the decision of Okare versus R in our third volume, I think. Yes, our third volume. Okare versus R. The page where the holding is 898. Okare versus R. It starts at 896, but the holding is at 898. There, my Lord, the court was simply saying that courts do not act on fanciful theories. They act on real evidence. The reason, my Lord, from the reading of the answer to the petition, the reading of the affidavit, my Lord, if you followed the cross-examination of Mr. Mbabazi, the theory was simple from the first respondent. In the second, third group.
My Lord, just forgot to follow. We don't have 898, the one being quoted.
You have
Our copy has 891. From there it goes to 916.
That's it. This is the same. It is there. The case is there. That one. Wait, you right now. That case. I think the pages were misfired. We always agree have both the violence. 898. My Lord, the point I was making before I was helping Mr. Uganda is this: that this theory that the first respondent put in his answer and pursued in cross-examination, okay, was tending to show, the theory was to show that because of the patterns that he referred to, trajectories, guesswork, okay, he was saying that I would have won in those polling stations. But that's not where he stops, my Lord. He's saying because of that he won in majority, I would have won in the 14, therefore the election would not be affected substantially. That's where he leads to. And my point, my Lord, that I'm making with this decision is that theorization basis and cannot be a reason for saying that the election would not be affected in a substantial manner. Let me also make this third point, my Lord, again as I walk away from this issue. What is at stake, my Lord, if we first put the rights respondent? Let's also think about the 16,640 voters who were disenfranchised. These people went to vote. We don't know how many went. We don't know how many turned up. But we know that people turned up to vote at these polling stations. But their results are nowhere to be seen, my Lord. They are not in the tally sheet. They were disenfranchised. My Lord, can we say, therefore, that their votes don't count, that their votes carry less weight, that their votes are irrelevant? My Lord, their lordships in the court of appeal have said no. Please don't treat them like that. This is the case of Mbagadi, Frederick Nkai versus Dr. Frank Nyafiso. My Lord, that is at page 901, but the holding is at page 926. This is volume now 3. The actual holding, my Lord, is on 926. Yes, but the authority starts at 901. My Lord, they are saying, please also look at the 16. Don't only look at the petitioner and the respondent who wants to be in parliament. There's something else at stake. It is the 16,640 voters whose electoral choice was not taken care of. And my Lord, disenfranchisement of these voters happened far from Mr. Muizi's cross-examination of they voted so they were not disenfranchised. No. Disenfranchisement does not only mean being stopped from voting. It goes all the way. When I vote and my vote is not counted or not tallied or given less weight, I am disenfranchised my vote. That is Apollo Kantinti. I will go back that decision. I don't want to take it back and forth. But what I'm saying is in that decision, that disenfranchisement also goes as far as that. When you go to that decision, you will see the various highlighted parts. Now, my lord, disenfranchisement is fatal. Disenfranchisement of a number as great as this, nearly double than the margin, nearly double the margin between the first respondent and the petitioner is fatal. The election cannot be upheld by one. Kantinti, my lord, is one of them. The other one I have is Atan Pokia. I think I also refer to it. My lord Kantinti have is that effect. My lord, we have highlighted that particular part. I don't have to go back. You cannot give the 16,640 any. Now, my lord, with that, on this point, I invite you to find and hold fast that there was non-compliance with the provisions of the Parliamentary Elections Act relating to elections, and that non-compliance, my lord, affected the result of the election in this instance. I now, my lord, I don't know if, yeah, I go to the next issue. The next issue is whether there was an illegal practice or any other offense under the PEA committed by the first respondent in connection with the election, personally or with his knowledge and consent. My lord, under this ground for setting aside the election, we pleaded for illegal practices or offenses. I'll begin with bribery. Bribery, your lordship, is prohibited under section 87, subsection 1 of the PEA. And my lord, from a long line of cases up to the apex court, they have interpreted that section again and again and crystallized 3 key ingredients of that illegal practice. For me to succeed on bribery, my lord, I should show you 3 things. Number 1, that a gift was given to a voter. 2, that the gift was given by the candidate or his agent. 3, that the gift was given to induce the person to vote for a candidate. Once I prove that, my lord, I have proved the illegal practice of bribery. My lord, that is stated, what I've just said is stated in the case of Gaddafi Nasur versus Sekabila Dennis, quoting the decision of Kizames versus Kusebe. Those ingredients that I have proof, my lord, the cases are in 3rd volume. It starts at 963, but the actual holding is at 927. The actual holding is at 987, but the authority starts at 963. My lord, I'll go through the evidence of each incident of bribery. And I'll begin with that of Maumbe Jodori. I'll go through one by one, my lord, evaluate the evidence, and then make a general comment on the law. I'll not speak about the law in each incident. I'll speak about the law generally. but I have to first take you through the evidence, my lord, for each incident. Now, I'll begin with Mawumbe John William. This gentleman, on the 9th of April 2025, saw an affidavit for us, a petition. My lord, I think in the examination you were able to note the numbers, the pages where that affidavit is. But for abundance of caution, my lord, is at page 1276 to 1278. In that evidence, my lord, this gentleman stated that he is a registered voter at Clinton Junior School KI to M polling station. My lord, we gave that voter's roll as part of our evidence. On election day, he says that he met a man called Ben Mukasa at Omar's place near a shrine under a jackfruit tree near a place called Zion Park. That place, my lord, is found in Chiganda zone in Kawempe North constituency, not very far away from where the polling station is. He said that when he got there, he found Ben Mukasa giving money to several people, and he gave him 5,000 shillings and asked him to vote for the first respondent. My lord, this witness came to the stand and was extensively cross-examined his affidavit, and he remained firm that he was given 5,000 shillings by Ben Mukasa. Ben Mukasa also gave an affidavit. I said, my lord, I refer to it without prejudice. He gave an affidavit where in paragraphs, my lord, if you could note them, 6, 7, 8, 9, 14, and 15, he made repetitive bare denials of having given this witness a bribe. He simply says, I did not see. Bare denials, my lord. He actually says to his face that I know these allegations are not correct because Mawumbe has said in the second affidavit that they are not correct. Of course, thankfully, my lord, that second affidavit is now out of the way. For Chamber Nathan Mwangs, the second incident, again, the registered voter at Clinton Junior School, KI to M, we have given the voter's roll, my lord. He says, on that day of the election, he went to this parking lot and found Nachove and Ben Mukasa. Nachove gave him 10,000 shillings. Again, my lord, the witness was cross-examined extensively, and rather than impeach, what was stated from that cross-examination, what I noted, is rather than impeach the fact that Nachove gave 10,000 shillings to Chamber, my learned friend who was cross-examining was only asking what the witness had done for Nachove to receive the 10,000 shillings. So the fact of receipt of the 10,000 shillings was not impeached. What the lawyer was trying to get around about was what was it for. And this was towards the day of the election. The witness said, I have no relationship with Nachove or Ben Mukasa, and there could never have been any other reason to give me the 10,000 apart from voting for the first respondent. Nachove saw an affidavit, my lord. I'm referring it without prejudice. Nachove made only bare denials. Okay, I did not give that man money. But what is striking are two things from her affidavit, my lord. If when you retire, you look at it. Two things lavishly strike from that affidavit. The first one is that Nachove does not deny in her affidavit knowing Chamber Nathan Mwangs. She doesn't say so in her affidavit. She only says, and I quote, that she does not know Chamber Nathan Mwangs pertaining to the issues of Kawempe North by-election. So she says, she doesn't say I don't know him. She says I don't know him with regard to issues of Kawempe North by-election. Something else striking from her affidavit, Nachove. She does not deny being an agent, the first responder. Others try to deny it generally, but this one doesn't deny it at all. My lord, I need to highlight in these two instances, if I go to the next one, I need to highlight the evidence they gave in court here during the examination when they stated that they were approached by Ben Mukasa and told and coerced and intimidated and whatever they said Ben Mukasa and whoever he did it with did to them. I must note that for these two incidents, that evidence that they gave here in the examination is critical, my lord. Okay, how they were approached by Ben Mukasa, again, that this evidence will disappear. That is a key highlight of those two incidents. On the third one, my lord, at Pentecostal Church polling center, Wanjala Solomon came to the stand. Wanjala Solomon came to the stand and said, I saw Ben Mukasa give money to voters who included Geoffrey Wamkulira. When he was at the stand, my lord, he demonstrated the distance between him and the veranda where Ben Mukasa was giving the money for. And as you could see, my lord, it was a very short distance. Wanjala could see what was going on. Something is striking from the affidavit of Ben Mukasa with regard to this particular incident, my lord. In that affidavit, from paragraph 1 to the end, Ben Mukasa does not deny that he was at that polling station. Nowhere does he say, I was not there. He only says, I did not leave because the presiding officer asked me to leave. Kind of literally saying, I left on my own. But he doesn't say, I was not there. Again, he says, he doesn't know I wasn't there. He says, I am not aware of any complaint filed against me at this polling station by Wanjala Solomon. That's what he says in his affidavit, but he does not say that Wanjala Solomon, you are lying, I was not at that polling station. He doesn't say that in his affidavit. Now, with regard, my lord, to those three incidents, there's something I want to highlight. Maumbe, Chamber, and Wanjala. Let me highlight this, my lord, with regard to those three incidents. All these three incidents, my lord, took place in Chiganda Zone, LC1. The polling station of Clinton Junior, KI2M, and Pentecostal Church polling center are both within Chiganda Zone, LC1. So Ben Mukasa was operating from Chiganda Zone. And he does not say, by the way, in his affidavit, or even in Nacho, none of them says they were not in Chiganda Zone on election day. None of them say so. In fact, from the evidence of Chamber Nathan Mount, my lord, this gentleman we're talking about, Ben Mukasa, is a resident of this Chiganda Zone. He's a leader of that zone. And he confirms that, my lord, in his own affidavit. So I thought I could highlight that bit, that this is all in Chiganda Zone. Now, at Sekati, Nabakoza Rita, bribery by Nabakoza Rita in Sekati Zone, one of the photos and everything. My lord, our witness, Nabukenya Margaret, came. And he said,
This first one was
the first one was Margaret?
by Mukasa.
Yes, all those three incidents, we have bribery by Mukasa. There were three cases. To Nabakoza, yes. Mukasa, my lord, and Nacho in the first three. Because Chamber was bribed by Nacho. So the first three instances is Ben Mukasa and Nacho. This one is Rita, Nabakoza. And I'll say this very, very, very briefly, my lord. Our witness came here, Nabukenya Margaret, and told us Nabakoza Rita went to a registered voter called Chibuka Mary Diana and gave her 1, 2, 3, 4, 5 items. 2, she stated that this was during the election campaign. This was during the campaign for the by-election. When Rita came here, my lord, she did not deny. She did not deny that she was at the residence of Mary Chibuka Diana. She did not deny that she gave out the items. All she tried to do was to give a different version now of what she was doing, okay, during this campaign period. But at least she doesn't deny that during this campaign she was at the residence of Mary Chibuka Diana and that she gave out these items. That is paragraph 12 of her affidavit in support of the first respondent's answer to the petition. When we cross-examined her, my lord, we were able to show that on this particular incident, when she went to Mary Chibuka Diana, she was wearing the party symbols of the political party of the first respondent. The photographs that he attached to try and give a different version of what she was doing, as we saw, my lord, towards the end of cross-examination, collapsed like a pack of cards, my lord. He started by saying, I took them with this phone. As it later transpired, the phones were different. Some she had gotten from Facebook. Later transpired, she didn't take them to the printer. The lawyer took them to the printer, blah, blah, blah. So that chain was completely destroyed. And so was her version of events as what happened during the campaign for the by-election of County. My Lord, also note, in all the incidents now, all of them, these people who are alleged to have committed the bribery, all of them are NUP leaders, National Unity Platform leaders. All of them. And they say so in their affidavits, my Lord. They are leaders and they are sponsored by the National Unity Platform. That is Rita, Annexure, and Ben Mukasa. My Lord, which now brings me to the affidavit Secretary General of the NUP, David Lewis. There, my Lord. Yes, my Lord. I was evaluating evidence, then I go to the law. Which brings the affidavit of Lewis Luongoya, where he says in paragraph 5, 6, 7, 11, and 12, he says in all of those paragraphs, he indicates, one, that the NUP sponsored the first respondent. That's not in doubt. The first respondent agrees with it. Two, that party functionaries were active in the campaign and on the day of the election. He states, we will see, my Lord, that officials of the party were there. He actually says himself, I was there supervising the polling stations. Actually said, I am the one who took care of the welfare of the agents of the first respondent. Now, let me go to the law, my Lord, touching on all of those points I've been talking about. Now the law. First of all, my Lord, who is a registered voter? Because I have to prove, remember the first thing, my Lord, I need to prove that the person who was bribed is a registered voter. Who is a registered voter? Section 1 of the Parliamentary Elections Act defines who a registered voter is. How? As a person who appears on the National Voters Register. Once you appear there, whether you have a national ID, whether you have a voter slip, whether you have what, all of those things don't matter. Their lordships in the Court of Appeal have twice told us that the registered voter is the one who appears in the National Voters Register. My Lord, for that position, I have the case of Gaddafi Nassau, which you have referred to earlier. My Lord, you will revert to it at some point. But the new one that I want to introduce, my Lord, is the case of Simon Muyanga Utaya. It is in our third volume, and the specific holding I want is at page 1016. 1016. Simon Muyanga Utaya. Am I pronouncing the name? Am I pronouncing the name?
My Lord, I'm married.
Simon Muyanga Utaya. Muyanja. He has corrected me, my Lord. The point I wanted to bring with that decision, Your Lordship, at that paragraph, at that page where I have taken you, is that for you to prove that you're a voter, you don't have to have a national ID. No. You don't have to have a voter slip, as I saw my colleagues representing my witnesses here. All that is irrelevant. Once you appear on the NPR, that is it. You're a voter. And my Lord, we have demonstrated that all people who were bribed in all these incidents were registered voters. Mawumbe is, Chamber is, Wamkubira is, Chibukameli Diana is. These were the 4 people who were bribed. We have demonstrated that all of them are registered voters. Second, my Lord, what was the purpose of the bribe? The third ingredient, I have to go back to the second one. My Lord, who gives money to a registered voter on the day of the election for anything else other than to induce them to vote for the first respondent? These people came here. They said, we don't have relationships with these people. We don't owe them money. They are not our relatives. So there is no other reason why they would have given us money apart from inducing us to vote for the first respondent. My Lord, for that, I don't want to waste too much of your time. I refer to the decision of Namboze at page 1064. You will see the decision there. It starts at 2023, but the actual holding is at 1064 and 1065. And I'll highlight it. And for now, on the part, my Lord, of what could have been the purpose? What is the reason why you're giving away these things? For now, my Lord, we submit that she gave out these items to a registered voter when the election was imminent. It was during campaign. Giving a gift to a voter during campaign is prohibited. These gifts were given during the official campaign period, which admitted on the stand and when the election was imminent. In Namboze, Bakaruwa, the Supreme Court said, no, actually, no, my Lord, that is Bada, Freddy Bada versus Professor Muyanda Mutebi. Professor Muyanda Mutebi, same situation. The election was 1 week away. Professor Muyanda Mutebi gave a cow. Their Lordships, the Supreme Court said that gift would not have been interpreted in any other way apart from a gift to a voter to induce them to vote at the election. Now, let me go to the second ingredient now. Now, my Lord, this illegal practice we are talking about, you have not seen me anywhere mention the first respondent himself. Okay? What now behooves me to prove and show to you, my Lord, is that this illegal practice was committed with his knowledge and consent or approval. I have submitted, my Lord, that all these people involved in this instance of bribery are NUP political leaders. NUP political leaders who, as I have said from the Affidavit of Ruwongoya, actively participated in the campaign and election of the first respondent. They are all NUP political leaders who actively participated in the campaign and election of the first respondent. And Mr. Ruwongoya puts them in the field for that purpose. And the first respondent, my Lord, says he is sponsored by his political party. That's fine. Now, my Lord, my argument is, this first respondent here, Mr. NALUKOOLA, cannot on the one hand take benefit of the good activities of what his party did, and on the other run away from the illegal practices of what his party officials did. He cannot approbate and reprobate. I'll give you an example, my Lord. In the affidavit of David Lewis, what does he say? He says, on election day, I moved around, supervising all polling stations and taking care of the welfare of the first respondents' agents. My Lord, Ruwongoya was not the candidate. He is the Secretary General of the National Unity Platform. And he's saying that's what he did. My point is, the first respondent cannot take benefit of that. Okay? That's okay for my party to do. They took care of the welfare of my people. When it comes to bribery, you say, no, those are not my things, I don't know those people. He cannot approbate and reprobate. My Lord, that's not a noble principle, but if it pleases you, I can refer you to the decision of the Supreme Court that has that principle at page Codro 1 of our bundle. Codro 1. The case name is Bison Okum and others versus UGCL and others. That's where the principle of approbating and reprobating comes. Let me also make this point, my Lord, about these officials of the National Unity Platform. These are not non-influential political functionaries or leaders. No, these are councillors from their areas of operation, from their areas of the constituency. These are councillors who clearly were deployed by the party in the areas which they represent in the national leadership, where they knew the terrain very well, so they could carry out the practice of bribing people with utmost sophistication. These are not any lousy NUP people. No, These are leaders. They are not your day-to-day street boys. No. These are leaders. These are national leaders, all of whom are of the national unity. What has the court said about people like that and bribery? What has the court said? My Lord, I refer to the decision of Yamukama James. Yamukama James versus Keja William. That decision, my Lord, is in this third one. Is in our third day band of authorities. It starts at page 1121, but the actual holding is at page 1163, my Lord.
We shall take a short break. We shall resume at 12:15.
I'm obliged, my Lord.
Kkooti Ben Mukasa mpaka eddakiika 2 oli ku Shalom Television Uganda Sibanyama mpereza ekyokola kya kabi ky'okola kya ttendo Dr. Nzanzi Nkuweereza ngenda kujja ku katono nkomewo ku ssaawa 6 n'eddakiika 2 nagambye musango guno kunyumira olina okugugoberera si buli kimu kyeyogera mu musango guno kijja kukunyumira si byonna byeboogera nti bigenda kukunyumira ekitegeera si byonna byogera mu musango guno tebigenda kukunyumira byonna olina obiwuliriza byonna olina okubiwuliriza owulire engeri gy'okola ki okitegedde ebintu bino byonna mulina okubigoberera byonna mubeera mulina okubira musebe nobeera ku tv ngaayogera mudule mumulabe mufune engeri gye mumwatakingamu oba mufune engeri gye mumureplayingamu okitegeera oba ofune engeri kugamba gwe n'otabiwulira ye agenda byogera eri kkooti ate obulina okumwanukula mu ngeri emu oba endala so togenda kwanukula muntu kutawulidde endowooza ye ndalimu abadde bayomba leero bulabulabulabula no omusango mulina okufolowinga era buli muntu ayogera omusango guno mulina okumuwuliriza ate mumanyi ebintu bino ebyo bitambula mutapinge mu link eyo musubscribe ku backup channel yaffe okyali wafuna channel ye bagibbye mwana okyali wafuna channel ye bagibbye kati bwe mugana okusubscribe ku eyo backup channel yaffe agenda okubba eniaffe engeri kiriya tusigala twefuna then mujja kuba munoonya nga temufuna kona mu kalinki waggulu awo ogenda osubscribe tutaga abantu 1000 tunawada okuwera ebisatu tutaga abantu 1000 tunawada okuwera 300 can you imagine kano wantuliwo abantu 400 wavaawo waki abantu nga 200 ne mugana musubscribe ku channel eyo kiba kyakabi kote omuddemu just 20 minutes just 20 minutes yankubira nampeeza
tebagenda zino saawa tugenda kumusaba mukaaga
mukone mu link eyo musubscribe ku backup channel yaffe bannange saagala ate nabakikola kikole ku bantu olwo channel ya Muganda Afunula gye batutto eki ekikeseza olwaleero njala bagenda okutwala eno kuba bagegezaamu dde ogitwala njala bagenda okutwala eno olwedi naye tusigala twefuna ababoyi twetaaga abantu 10 batukiriza okubirako live kweri channel endala twetaaga abantu 10 batukiriza okubirako live Triskila ogamba otya I come on camera okay kamala connect hapo na microphone nje kukana
Njagala kunsindikirako kalina kansindikire kupapye FARIDAH mu FARIDAH.
Kale baboy tudengane ku ssaawa 6:20.